Let me tell you about a building on a quiet street in Zurich. No sign, no logo, no indication from the outside that anything of significance happens there. If you walked past it, you would assume it was a private residence. A well-maintained one, certainly, but unremarkable. Behind that door is one of the oldest private banks in the world. Its clients hold a combined wealth measured in the hundreds of billions. Their names appear in no public database. Their accounts generate no publicly available records. Their transactions move through structures so deliberately obscure that even sophisticated financial regulators struggle to trace them. And that obscurity is not a side effect. It is the product. The clients of that bank are not paying for investment returns alone. They are paying, at extraordinary cost, for invisibility, for the ability to exist in the world as one of its most powerful actors, without anyone outside a very small circle knowing precisely how powerful they are. This is not unique to Switzerland. It is a global phenomenon, practiced by the world's most enduring dynasties, the Rothschilds, the Agnellis, the Wallenbergs, the old New England WASP establishment, the Gulf royal families, the great Asian business dynasties, with a consistency and sophistication that reveals something important. For old money, privacy is not a preference, it is a strategy. And it is arguably their most valuable financial asset. Today we are going to go deep on exactly why. We're going to look at the history, the mechanisms, the real financial logic, and, perhaps most provocatively, what the relentless public visibility of the modern era means for dynasties trying to survive it. This is one of the most important videos in this series. Stay with me. The philosophy, why visibility is vulnerability. To understand why old money values privacy so deeply, you need to understand a concept that sounds simple but has profound implications. Visibility is vulnerability. Every piece of information about your wealth, your assets, your family, your relationships, and your intentions that is publicly known is a piece of information that can be used against you by a competitor, by a litigant, by a regulator, by a criminal, by a journalist, by a political opponent, by a family member with a grievance, by a government with an agenda. This is not paranoia, it is historical experience accumulated over centuries. Consider the most literal version first: physical security. The kidnapping of wealthy family members has been a persistent threat throughout history and remains one today. The most famous case in American history is the 1932 kidnapping and murder of Charles Lindbergh Jr., the 20-month-old son of aviator Charles Lindbergh. Lindbergh was famous, his address was known, his family's movements were documented in the press. The tragedy that followed became the defining event in the security practices of wealthy American families for generations. In Italy, the kidnapping industry targeting wealthy industrial families was so prevalent in the 1970s and 1980s that it became almost routine. The most famous case, the 1973 kidnapping of John Paul Getty III, grandson of oil billionaire J. Paul Getty. The kidnappers sent Getty's severed ear to a newspaper to pressure the family into paying. Getty eventually paid, but only after his grandfather's initial refusal to pay the ransom had turned the case into a global media spectacle. The Getty family's response to this experience became a template for wealthy family security globally: radical reduction of public visibility. Family members' addresses, movements, and activities were systematically removed from public knowledge. The family's subsequent wealth management, philanthropy, and business activities were restructured to minimize the public profile of individual family members. But physical security is only the most visceral version of the vulnerability that visibility creates. The financial vulnerabilities are equally serious and far more common. Legal targeting. When the public record shows clearly that a family controls significant wealth, it invites litigation, not necessarily legitimate litigation, though that exists too, but strategic litigation, lawsuits filed not because the plaintiff has a genuine grievance, but because the defendant's known wealth makes a settlement economically rational, even when the underlying claim is weak. Litigation finance, the practice of third-party investors funding lawsuits in exchange for a share of the proceeds, has grown into a multi-billion-dollar industry. Firms specializing in litigation finance actively identify wealthy targets, whose public financial profiles suggest that settlement is cheaper than defense. Invisibility is, quite literally, a defense against this industry. Regulatory and political targeting. Visible wealth also attracts regulatory attention and political targeting in ways that invisible wealth does not. The families whose names appear regularly in Forbes rankings, whose properties are photographed in architectural magazines, whose charitable gifts generate press releases. These are the families that feature in political speeches about wealth inequality, that attract IRS scrutiny, that become the subjects of congressional investigations. The families whose wealth is held in trusts, managed through family offices, and deployed through foundations with minimal public attribution. These families operate in the regulatory shadows not because they are doing anything illegal, but because invisibility reduces their exposure to the arbitrary exercise of governmental and political power. Warren Buffett has noted this dynamic with characteristic directness. Despite being one of the world's most recognizable wealthy individuals, a visibility he has strategically cultivated for his own purposes, he has observed that the families who have maintained their wealth most effectively over multiple generations are almost universally people whose names the general public does not know. The history, how privacy became a dynasty strategy. The strategic use of privacy by wealthy families did not begin in the modern era. It has roots going back centuries, and understanding the history reveals just how intentional and sophisticated this practice has always been. The Rothschild cipher. When Mayer Amschel Rothschild established his banking network in the late 18th century, he faced an acute problem. He needed to communicate sensitive financial information across 5 different countries through postal systems that were routinely intercepted by governments, competitors, and criminals. His solution was the development of a private family cipher, an encrypted communication system used exclusively within the Rothschild family network. Letters between the Frankfurt, London, Paris, Vienna, and Naples branches were written in this cipher, which was never shared outside the family. Financial positions, market intelligence, political information, and strategic plans moved through the network in a form that was, to any interceptor, completely unreadable. This is, in contemporary terminology, operational security, the systematic protection of sensitive information from adversaries. And the Rothschilds were practicing it in the 1790s. But the Rothschild privacy strategy went beyond encryption. Mayer Amschel made a deliberate decision to conduct the family's most sensitive business through personal meetings rather than written communication wherever possible, understanding that the most secure information is information that was never recorded. This principle, minimize the documentary record of sensitive activities, has been a cornerstone of sophisticated wealth management ever since. The Swiss banking tradition. The Swiss banking secrecy tradition that has made Geneva and Zurich the centers of global private wealth management did not emerge accidentally. It was the product of specific historical circumstances that created a durable alignment between Swiss political interests and wealthy clients' need for privacy. Switzerland's formal banking secrecy laws, codified in the Swiss Banking Act of 1934, were partly a response to Nazi Germany's attempts to identify and seize the assets of German citizens, including Jewish families fleeing persecution, held in Swiss accounts. The legal framework that emerged made it a criminal offense in Switzerland for a banker to disclose client information without the client's consent. For the next 80 years, this framework made Switzerland the world's premier destination for wealth that needed protection from political risk, expropriation, and visibility. At its peak, Swiss banks held an estimated 1/3 of all cross-border private wealth globally, not primarily because Swiss banks offered superior investment returns, but because they offered superior privacy. The Swiss model was eventually eroded by international pressure, the United States' aggressive pursuit of tax evasion through Swiss accounts in the 2000s and 2010s, culminating in the FATCA legislation and the erosion of Swiss banking secrecy in its traditional form. But it established a global template for privacy as financial service that has since migrated to other jurisdictions. Singapore, the Cayman Islands, the British Virgin Islands, Luxembourg, and, perhaps most surprisingly, the American state of South Dakota. The English aristocracy's privacy architecture. The English landed aristocracy developed its own privacy architecture over centuries, one built not primarily through financial secrecy, but through social and institutional structures that made wealth invisible without technically hiding it. The great English estates, the Devonshires at Chatsworth, the Bedfords at Woburn Abbey, the Marlboroughs at Blenheim Palace, held their wealth in landed assets that were on paper publicly known. The estates were registered, the titles were public record. But the financial details, how much income the estates generated, how the family's liquid assets were managed, what the terms of family trusts were protected by a combination of social norms. Discussing money was considered deeply vulgar. Legal structures, trusts that predated modern disclosure requirements, and institutional privacy, the great private banks like Coutts, Horries, and Child & Co. operated under norms of absolute discretion that preceded any formal legal requirement. The social norm against discussing money, which persists in old money culture today, is not merely affectation, it is a privacy mechanism. If the culture of your class makes it deeply inappropriate to inquire about someone else's finances, you have created a social enforcement mechanism for financial privacy that requires no lawyers or legislation. The modern architecture of financial privacy. In the modern era, the tools available for managing financial privacy have become extraordinarily sophisticated. A full ecosystem of legal, financial, and institutional mechanisms that can render even very large fortunes essentially invisible to public scrutiny. Let's walk through the architecture. Shell companies and holding structures. The most basic building block of financial privacy in the modern world is the holding company, a legal entity that owns assets without those assets being directly traceable to the individual who controls them. Here is a simple example of how this works in practice. Rather than personally owning a $20 million Manhattan apartment, which would be recorded in the public property registry with your name attached, you establish a Delaware LLC. The LLC purchases the apartment. The public registry shows that the LLC owns the property. Your name does not appear. Who owns the LLC? A holding company in the Cayman Islands. Who owns the Cayman Holding Company? A trust in South Dakota. Who controls the South Dakota Trust? A corporate trustee, a trust company, whose client files are protected by South Dakota's strong privacy laws. At each layer, the trail becomes harder to follow. Not impossible. Sophisticated forensic investigators, investigative journalists, and determined regulators have developed tools to pierce these structures, but difficult enough to deter casual inquiry and provide significant protection against most threats. This kind of layered ownership structure is standard practice for high net worth family wealth management globally. The Panama Papers, leaked in 2016, and the Pandora Papers, leaked in 2021, exposed the extraordinary scale of this practice, revealing that world leaders, billionaires, and established dynasties from virtually every country in the world maintained assets through exactly these kinds of layered offshore structures. The International Consortium of Investigative Journalists, which analyzed both leaks, estimated that approximately $32 trillion in private wealth was held in offshore structures globally at the time of the Panama Papers disclosure. That figure represents approximately 10% of global GDP, held deliberately in structures designed to minimize visibility. The private trust company for the wealthiest families, the standard corporate trustee arrangement, using an established bank's trust department, creates an unwanted disclosure risk. The bank knows everything about the family's financial position. The solution, adopted by many dynastic families, is the private trust company, a trust company established and owned by the family itself, licensed to act as trustee for the family's trusts. The PTC employs its own trust officers, maintains its own records, and is subject only to the regulatory requirements of its domicile jurisdiction, typically a privacy-friendly state like South Dakota or Nevada. The result is a trust administration structure that is entirely self-contained within the family. The information about assets, beneficiaries, and distributions is held by an entity controlled by the family, in a jurisdiction with strong privacy protections, with no third-party institution holding information that could be disclosed through a subpoena, a data breach, or a regulatory inquiry directed at a major bank. Privacy in real estate. The beneficial ownership question. Real estate is one of the most publicly traceable forms of wealth. Property registries are public in most jurisdictions, and major property transactions are often reported in the press. The use of shell company ownership structures has been the primary privacy tool here, but it is increasingly under pressure. Following concerns about money laundering and criminal asset hiding through anonymous real estate ownership, the United States Treasury Department's Financial Crimes Enforcement Network has been gradually expanding disclosure requirements for real estate transactions, particularly in major markets like New York, Miami, Los Angeles, and San Francisco. The Corporate Transparency Act, enacted in 2021, requires most U.S. companies to disclose their beneficial owners to FinCEN, a significant erosion of the shell company privacy model. Sophisticated families and their advisors are adapting. Structures that were previously straightforward are being redesigned to maintain privacy within the new legal constraints, using combinations of trusts, charitable entities, and compliant holding structures that satisfy disclosure requirements while minimizing public-facing transparency. The digital privacy challenge. The emergence of digital financial systems, electronic payment records, digital asset databases, social media footprints, and data broker ecosystems has created entirely new privacy vulnerabilities that previous generations of dynastic wealth managers never had to contend with. A digital footprint can reveal far more about a family's financial position, movements, relationships, and vulnerabilities than any traditional financial record. Credit card transactions reveal spending patterns. Location data from smartphones reveals physical movements. Social media posts reveal relationships, properties, and assets. Email metadata reveals professional and personal networks. The most privacy-conscious old money families have responded with practices that sound extreme by modern standards, but are entirely rational given the threat model. Members of the family use burner phones for sensitive communications. Business meetings of strategic significance happen in person, in locations chosen for their lack of surveillance infrastructure. Personal social media profiles are either non-existent or maintained under pseudonyms. Major purchases are routed through legal structures rather than personal accounts. This is not eccentricity. It is the application of the same operational security principles that Mayer Amschel Rothschild applied with his family cipher in 1790, updated for the surveillance infrastructure of the 21st century. Privacy as competitive advantage, the financial logic. We've talked about privacy as defense, protection against litigation, kidnapping, regulatory targeting, and political risk. Now let's talk about something that gets even less attention: privacy as offense, as a source of competitive advantage in financial markets. Information, asymmetry, and investment returns. In our last video, we discussed how old money families maintain information advantages through their networks, access to private deal flow, advance intelligence about regulatory changes, relationships with decision-makers across multiple industries. Privacy amplifies this advantage in a specific and measurable way. A family whose financial positions are not publicly known can act on its information advantages without triggering the market reactions that public visibility would cause. When a major institutional investor, hedge fund, a pension fund, a publicly known family office takes a significant position in a private company or asset class, that action is often visible or inferable by market participants. Other sophisticated investors watch who is buying what. A known, respected investor taking a position is itself a market signal that drives prices up, reducing the returns available to the original investor and eliminating the advantage their research created. A family whose identity is unknown, whose transactions flow through layered entities with no publicly identifiable owner, can take positions without signaling them. The information advantage is preserved because the action that acts on it is invisible. This is not hypothetical. Research in financial economics on informed trading consistently shows that traders with genuine information advantages earn higher returns when their identity and positions are concealed than when they are visible, because visibility invites front-running, imitation, and competitive response that erode the advantage. Negotiating from invisibility privacy also confers significant advantages in direct negotiation, in real estate transactions, business acquisitions, and deal-making. When a known wealthy buyer approaches a seller, the seller's negotiating position is immediately strengthened by their knowledge of the buyer's resources. A seller who knows that their counterpart has $500 million in available capital will extract a higher price than a seller who believes they are dealing with a modestly capitalized buyer of unknown means. Old money families conducting major transactions through anonymous holding structures preserve negotiating leverage precisely because the counterparty cannot calibrate their demands against known wealth. The transaction happens on more favorable terms, and over many transactions, this advantage compounds into very significant financial returns. Tax strategy and privacy. The relationship between privacy and tax optimization is complex and legally sensitive, but it is real and significant. Tax planning for large fortunes is an ongoing, sophisticated, multi-jurisdictional exercise. The strategies employed by sophisticated tax counsel are not secrets. They are legal planning techniques documented in tax law. But the specific application of those strategies to a specific family's circumstances, which entities hold which assets, which transactions have been structured in which ways, what the family's tax basis is in various holdings, is information that has direct financial value. A competitor who knows your tax basis in an asset knows your cost to exit a position. A business counterparty who knows which entities you use for different types of transactions knows more about your strategy than any negotiator should. A government with a policy agenda has a more powerful case for targeted legislation when it can identify specific families and structures to name publicly. Privacy in tax planning is not about hiding illegal behavior. It is about protecting the legitimate application of legal strategies from the competitive and political consequences of visibility. What happens when privacy fails? The cautionary cases. The value of privacy becomes most vivid in the cases where it was lost, and the consequences that followed. The Panama Papers and Pandora Papers. When the Panama Papers were published in April 2016, the International Consortium of Investigative Journalists released information from 11.5 million leaked documents from the Panamanian law firm Mossack Fonseca, exposing the offshore structures of hundreds of thousands of individuals and entities globally. The financial and reputational consequences were swift and severe. The Prime Minister of Iceland resigned within days. Pakistan's Prime Minister Nawaz Sharif was eventually removed from office and convicted of corruption following revelations in the papers. 12 national leaders were named, along with 140 politicians from 50 countries and hundreds of wealthy families and individuals from virtually every nation. For the individuals named, the consequences went beyond reputational damage. Asset freezes, tax investigations, lawsuits from business partners who claimed the revelations indicated hidden conflicts of interest, divorce proceedings that gained new evidence, in some cases, criminal investigations. The families whose structures were not found in the Panama Papers because they used different service providers, different jurisdictions, or structures that were simply not breached, were, by definition, protected from all of these consequences. Their privacy held. Their assets remained undisturbed. The Panama Papers is the most vivid demonstration in modern history of what the failure of financial privacy costs, and the lesson was absorbed with extraordinary speed by the world's sophisticated wealth managers. The Getty Kidnapping Revisited. We mentioned the Getty kidnapping briefly in Part 1. Let's go deeper, because the Getty case illustrates not just the physical security dimension of privacy failure, but the cascading consequences. J. Paul Getty Sr. was, at the time of his grandson's kidnapping in 1973, the world's richest private citizen. This fact was widely known. It had been reported in the press. Getty himself had given interviews about his wealth. His grandson, John Paul Getty III, was a visible, publicly identified member of a publicly identified wealthy family. The kidnappers chose their target specifically because of this visibility. The ransom demand, $17 million, was calibrated to the known scale of the family's wealth. The negotiations were protracted and brutal precisely because both sides were negotiating in public. Every development reported in the press, every statement analyzed by the media. The family paid approximately $2.9 million in the end, the maximum that was tax-deductible under American law at the time, a fact that Getty Sr. made publicly known, generating worldwide condemnation. The total cost of this visibility, the ransom, the legal costs, the security upgrades, the psychological damage to the family, the reputational harm from Getty Sr.'s perceived callousness, was measured not just in dollars, but in the permanent alteration of the family's relationship to public life. The succession problem and public wills. A less dramatic but financially significant privacy failure occurs at the moment of generational transfer when wills become public documents. In most jurisdictions, a will that passes through probate becomes a public record. This means that at the moment of death, a family's asset structure, what was owned, how it was valued, who received what, becomes publicly known to anyone who cares to look. For families without adequate trust architecture, this disclosure is both a privacy failure and a financial vulnerability. Potential litigants who were unaware of the full extent of the estate now have a roadmap. Tax authorities have documented evidence of asset values. Business counterparties and competitors learn details of the family's financial position that were previously unknown. The solution, placing assets in trusts before death so that at the moment of death there is little or nothing to pass through probate, is one of the primary drivers of sophisticated trust planning. The will becomes a document of minimal financial significance because the real assets were transferred years earlier through structures that remain private. The modern paradox, visibility, social media, and dynasty survival. Here is the central tension facing old money dynasties in the 21st century. And it is genuinely unresolved. The tools for financial privacy have never been more sophisticated. But the cultural pressure toward visibility has never been more intense. Social media has created an environment in which visibility is rewarded economically, socially, psychologically. The influencer economy pays people to expose their lives. Luxury brands pay wealthy individuals to be seen using their products. The attention economy monetizes exposure in ways that create genuine financial incentives for the children of wealthy families to be publicly visible. And yet, as we've documented throughout this video, that visibility creates real, measurable, financial, and physical risks. The dynasties navigating this tension most successfully are doing something subtle and sophisticated. They are managing a visible surface while protecting an invisible interior. The family foundation has a polished Instagram account and a professional communications team, carefully presenting a philanthropic narrative that shapes public perception while revealing nothing about the family's actual financial position. A family member participates visibly in the arts, in philanthropy, in civic life, building social capital and maintaining institutional relationships, while their personal financial life remains completely opaque. The family's properties, investments, trust structures, and business interests remain invisible. The family's values and social presence are carefully, strategically visible. This is the old money solution to the modern visibility paradox. Curate the signal, protect the substance. Be known for what you choose to be known for. Be unknown for everything else. The Wallenberg family of Sweden, one of Europe's most powerful industrial dynasties, controlling companies that employ approximately 40% of Sweden's stock market capitalization, is perhaps the world's best modern example of this strategy. The family is known in Sweden. Their foundations and their companies are publicly visible. But the family members themselves maintain extraordinary personal privacy. Their financial positions, their family structures, their personal lives, these are protected with a consistency and effectiveness that is almost without parallel among families of equivalent power. They have been called the most powerful family nobody knows. And that invisibility, in a world of ever-increasing transparency pressure, is an achievement that has required continuous, deliberate, sophisticated effort. Let's bring this together. Old money dynasties treat privacy as their most valuable financial asset because, as we have now seen in full, it functions as exactly that. It is a defense against litigation, kidnapping, regulatory targeting, and political risk. It is a competitive advantage in investment markets, where invisibility preserves information advantages and negotiating leverage. It is a legal architecture that allows wealth to compound across generations without the erosive effect of public scrutiny. And it is a survival mechanism. The dynasties that have maintained their power across centuries have, almost without exception, maintained their privacy with equal consistency. The failure cases, the Vanderbilts, the Gettys, the families exposed in the Panama Papers, share a common thread. Visibility, whether of lifestyle, of asset structure, or of financial position, created vulnerabilities that were eventually exploited. The success cases, the Rothschilds, the Wallenbergs, the great private banking families of Europe, share an equally consistent thread. Radical, deliberate, multi-generationally maintained privacy about the substance of their financial lives, paired with strategic, carefully managed visibility about their public roles and values. This is not about hiding. It is about understanding that in a world where information is power, controlling your own information is the most fundamental exercise of that power. And here is the principle that applies regardless of your wealth level. Every unnecessary piece of financial information you make public is a vulnerability you have created. Every public display of assets is an invitation to those who would target them. And every generation that grows up without understanding the value of financial privacy is a generation less equipped to protect what the previous generation built. The old money lesson, at its core, is this: the most powerful thing you can do is make sure nobody knows exactly how powerful you are. Comment below, does this change how you think about financial privacy? Are there things in your own life you'd handle differently after watching this? Hit like if this gave you a genuinely new way of thinking about wealth and privacy. It helps more people find this series. Subscribe and hit the bell. Share this video with someone building serious wealth. The privacy principles in this video are things most financial advisors never talk about. I will see you in the next one.